Be seated. Good morning. It's nice to see you. We are here for oral argument in cause number 1 CA CV 130424, Sullivan versus Holmes et al. For your information, and I'm sure you've heard this before, these proceedings are being both audio and video recorded. So barring any unforeseen problems, you can watch YouTube and critique yourself in a couple of weeks, and good luck to you on that. Counsel, each side will be entitled to 20 minutes. We would ask that you respect the time period. The timer located on the podium will let you know how much time you have left. An appellant, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know so we can avoid taking up too much of your time. However, ultimately, your reserving of rebuttal time will be up to you. We've reviewed the briefs and conferenced this matter, so we are well aware of the facts and issues attendant to the argument. You might want to keep that in mind in how you address and what you address to the court this morning. And counsel, when you come forward to the podium, I would ask that you state your name and who you represent. And with that, counsel, you may begin.
Good morning. May it please the court, Chris Barsky for the appellant Charles Sullivan. I'd like to try and reserve 5 minutes, but we'll see how that goes. The basis for this appeal is really kind of twofold. First is whether there's an enforceable contract given the circumstances and the language of the contract. And the second is the nature and the extent of damages, if any. I wasn't, just to note for the court, I wasn't the attorney at trial, so I took this over just for appeal. So I'm relying off the records and the transcripts, much like the court is. As the court knows, my client tentatively entered into an option to purchase a parcel of land with premium payments of $2,000 a month for 12 months. That contract he never went forward with, and it ended up...
Counsel, let me make sure I understand something. The terms of the option contract, and it was signed by both parties, the terms of the option contract was $2,000 per month to keep the option open. And it's my understanding, at least from the record, that the position of Mr. Sullivan was, I never intended to do this. I never intended to make any payments. I never intended to use the option. And I guess, I mean, in essence, so it's sort of an illusory contract because it's sort of saying, well, offer acceptance, but there's no consideration unless I want to pay for it. And therefore, the contract is basically a nudum pactum. It's just illusory. Now, that was his position at trial?
Yeah, I think
right?
that was his position at trial, and I tried to understand that myself, saying there's no consideration, et cetera. I think the best way to put it is his understanding was it wasn't accepted until he tendered payment.
Okay, but they both signed it. I mean, you have an offer and acceptance. Both parties signed it. There's an offer and acceptance. The question is there consideration?
Sure.
So let me, assuming that's the case, I understand his position was, well, it's not accepted until even though he was, and this becomes who's the offerer and who's the offeree. Because in essence, as I understood the trial testimony was, he came to her, Ms. Fernandez, and said, I'd like to lease this for a long term. She said no. He said, well, how about an option to buy with a long-term lease? She said, oh, that sounds like a good deal. And so then he draws up the option agreement. She adds a clause, and they both sign it. Then he never makes any payments. That's a fair summary of what happened, right?
That's correct.
Okay. So now at trial, my recollection is that she testified, well, there was more than this. That, there's more than just the four corners of the option agreement. And remember, this is a counterclaim. But she's arguing, she says, I wouldn't have entered into the lease, long-term lease, except that, because I have these two other tenants, except that he said, I'll enter into an option to buy. And therefore, she relied on that, and so by terminating the lease and returning the deposit to the two other proposed tenants, she suffered a detriment by under the option agreement. At least that's her, my understanding, that was her basic testimony. Is that accurate?
Yeah, I disagree with the detriment part, but I do agree that was her testimony.
But she was but I mean, that would amount to a detriment, that she deferred leasing to two other people. And I'm not asking you to agree that that's, to concede that that's a detriment. I'm just saying that's what happened.
Sure.
So my first question is, did trial counsel object to that testimony saying, gee, you know, that's not relevant because we're looking at the option agreement?
Not that I'm aware. I mean, he didn't have trial counsel, I'll tell you that, and I don't think he made many objections himself, so I will.
Represented himself at trial?
Yeah.
Okay.
Counsel, let me ask you something and hopefully head back to where you were before. You said your client disagreed that he ever entered into the agreement. Let's be specific. Two agreements, correct?
Right.
There is the rental agreement. Your client's never disputed that he entered into that agreement, correct?
That's correct.
In fact, he functioned under the agreement, paid the rental sums until it was terminated with an unlawful detainer action, correct?
Correct.
Okay, so we're setting that aside, right?
Sure.
Independent of that, there's an option to purchase. Your client's position, as I understand it, is that there was a conditional, some sort of a conditional acceptance written into the agreement that said that, in fact, I've got it here, but in consideration of the payment of $2,000. So he's stating his consideration is limited to the $2,000?
I would say, yeah, we agree that that's a contract per se. The part with his performance and kind of a condition precedent to her obligation, which is the irrevocable offer, the option, was the payment of the $2,000.
So really what the written option agreement itself would be is just some kind of an agreement to agree, and the payment of the money would be his agreement to agree, or if his final agreement?
That's our position. It's an agreement, an embodiment of the condition precedent, the acceptance by performance, which would be the tender of the $2,000, which would trigger her corresponding duty.
So effectively, she is bound with the signing of the option agreement. He isn't bound until he makes the $2,000 payment.
No, I disagree. I think neither party is bound until the tender of the premium payment. When you look at the language of the contract, it says, in consideration of the payment of the option or payment by the optionee to the owner of the option price, owner grants the optionee that option to purchase the property.
So are you telling me that if he tendered the $2,000, she could say, no, I've changed my mind?
No, if she accepts the $2,000,
If she rejects the $2,000,
I don't think she can reject the $2,000.
so she is bound by the agreement.
She's bound by the agreement if she accepts the $2,000.
But she has to accept the $2,000.
Correct.
Can you distinguish that for me? She's not bound unless she accepts, but she has no choice but to accept. How is she not bound by the agreement?
Well, she's bound by the agreement to the extent that if she accepts the tender of the premium payment, or if he tenders premium payment, she then has to refrain from selling that property.
He will assert that she's in breach if she doesn't accept the tender payment.
Yes.
Thank you.
Okay. You know, there's an integration clause in the contract, the option contract. Did anybody raise that below?
I'm not aware of it. I'll let Mr. Swift comment on that, but I don't recall that from the transcript.
His testimony was, as I understand his testimony was, you know, it shouldn't have come to any surprise to her that I wasn't going to pay the $2,000 because I never intended to do it. It was something I never intended to do. Was there any testimony that he told her that? That he told her before they signed the agreement, by the way, by signing this agreement, I never intend to perform, to pay you $2,000 a month?
No, I'm not aware of any conversations prior to signing that agreement, and I don't know quite at what point he decided that it wasn't in his best interest to go forward with that. But I know within a month or so of the contract, June 9th, I believe, that she was aware that he didn't want to go forward with the contract for one reason or another.
And how do you know that? Where in the record does that come up?
That's in the transcript when he notified her by email. That was the email June 9th when she finally got it straight with her bookkeeper and was asking him for the $2,000, what's going on, and he says, well, you knew that I don't want to go forward with this. You know, I didn't accept your contract.
I mean, the option agreement required him to make the first monthly payment upon signing the option, which clearly he didn't do.
Right. So that was, I think
Did
that was,
anyone challenge that at that time?
I don't think the appellee challenged it at the time. I don't think she made any mention of, what's going on, how come I didn't receive the $2,000? And that was, I think, my client's position, is you should have known right at the beginning I didn't tender $2,000 under this option agreement. I don't want to go forward with it.
But clearly, between May 9th, between the signing the agreement and June 9th, when she's saying, what's going on here, she's under the implicit, construing the record in the light most favorably to affirm it, which we have to do, because it was a trial, is that she was under the understanding that she and he were both bound between at least until June 9th. Right? I mean, that, that payment was not, no one ever communicated to her that he, by signing this agreement, he never had any intent when he signed it to perform. I mean, isn't that,
I mean, I don't
assume that?
Yeah, I mean, I can't testify to his intent. I don't think it was on the record below.
I know, I'm just saying, given that, construing the evidence in the light most favorable to affirming, if she comes to him sometime after the contract is signed and saying, yeah, I just, learned that you never paid the $2,000, that would imply that she never understood prior, and that he never communicated to her when they signed the contract. By the way, I'm signing this, but I don't have any intent to perform.
Perhaps. I mean, I don't want to allude to the intent to perform, but,
Sure.
I think he didn't want to go forward with performance, but
And he wanted to go forward with the piece.
I think so. But again, I think, when the consideration is the payment and she doesn't receive payment, she doesn't have any duty to hold that offer open for him to do anything. So really, it didn't trigger her obligation to give him anything in return. And that kind of gets to the damages in this case, is if she didn't have any duty to refrain and she really didn't refrain or give him an irrevocable offer, and he didn't really give her the payment, it's kind of, we're kind of in the status quo here.
Isn't it more of an election of remedies issue? I mean, she could have sat there, I could sort of see her view of, well, I got this guy who's a tenant. He owes me $2,000 a month. I think he owes me $2,000 a month. I can elect to terminate the option, saying you're in breach, or sue you now, or seek specific performance of his performance of it, or wait until the year's up and then say, do you want to, maybe he'll come forward with $24,000 and he'll change his mind and say, I want to buy this property. So let me see what happens, and then I have this remedy. I mean, so isn't it an election of remedies issue?
I mean, I disagree with the election of remedies portion, because, I think it gets back to the original portion when it's performance by payment, acceptance by payment. I don't think it doesn't say, in consideration of the promise to pay $2,000 a month.
Mm-hmm.
If that was the case, she could perhaps wait a year and then sue and get her $24,000.
That's why I
back.
went back to this idea of the detriment, because she's suddenly testifying, not suddenly, she's testifying that, well, this convinced me to go rent to him for a longer term, and therefore that could act as alternative consideration. I mean, I don't know if you see where I'm going, but I'm asking a series of questions that say, well, if she comes in and testifies without objection that I suffered other harm by entering, I only entered into the lease because of this option, and I suffered some detriment by doing that, and no one raises, well, wait a second, that's, it's inadmissible parole evidence, or says, well, look at the integration clause, then it seems to me the trial court has a right to rely on that testimony to say, well, she suffered some detriment by entering, and that would act as additional consideration, because that was the understanding of the parties when they entered into the two documents.
Right, I understand what you're saying, Your Honor, but I think in this case, if she has a detriment, we need to look to that detriment for damages. She can't just circle back to the $24,000. If she rented it to my client for the same lease rate as somebody else, and eventually she kicks my client out and then continues to rent it and finds additional renters, this is a very sellable property, then there's really no damages associated with that detriment. You can't I don't think she can just go back to the $24,000 and say that was my detriment. And when you look at, I think that Steiner case out of California, that's kind of how they came down. They said, you know what, the consideration wasn't paid, or, you know, the premium wasn't paid, but still the appellee or the defendant in that case went out and they did some parcel splits, they had some architectural guidelines, so they looked to that for her damages, and that's really where I think she has to look in this case for damages. I don't think she can just circle back to the $24,000.
Was that argument made below?
Probably not. That's one of my problems.
Well, and I was going to ask you that too. You're
know.
in a unique position. It's difficult enough to take a case only on appeal when it's been tried by another lawyer, but you're taking over from a client who represented himself. And so if he didn't make those arguments about damages below, you know, under the waiver doctrine, it's kind of difficult for us to consider those for the first time on appeal. Can you think of anything in the record that sort of teed up the damages issue in the Superior Court?
I'm not aware of anything on the record. Again, you know, not having tried it, it's a little bit harder to go back and try to remember, only reading the transcript a few times. But, you know, I do know they did touch on it. I know the trial court actually, the judge actually questioned in one of his rulings, you know, was there a detriment associated with not renting? So I think it was considered, and, you know, somehow that must have been raised, but I don't know the arguments my client advanced to get there. So. That being said, I think there's a few minutes left I'd like to reserve unless the court has anything more of me.
Thank you.
Thank you.
May it please the court, my name is Tom Swift. I represent the Appellee Homes Etc. LLC. Rosemary Fernandez rented the Paradise Valley home to Charles Sullivan because he promised to pay $2,000 per month for an option to purchase the property in addition to the $5,000 monthly rental. He would not have secured the lease but for that promise.
Can I jump in there? It raises an issue I think Judge Kessler raised with Mr. Barsky. The integration clause would typically preclude our consideration of things like that. In fact, this integration clause says that we're not to consider other inducements and promises. However, this case was tried, and apparently that type of evidence came in without objection. Were you trial counsel?
I was, Your Honor.
And so that evidence all came in and was before Judge Fenzel without objection?
That is correct, Your Honor.
So it's your position that that the integration clause shouldn't prevent us from considering that testimony and determining the intent?
Yes, Your Honor, there was no objection below. In addition, there's case law that the parole evidence rule does not bar extrinsic evidence of what the true consideration for a contract was.
What's your best case on that?
I have two cases. There's one that states parole evidence is admissible to show the true consideration. That's Merrick versus United States Rubber, 7 Arizona Appellate 433, 440 Pacific 2nd 314. That's a 1968 case.
7 Arizona App 433.
Yes, Arizona App 433, 7 Arizona App 433.
What's the other one?
That case is State versus Wilson, which holds that even the parole evidence is admissible even if it conflicts with what the stated consideration is in the
Cite on that.
It's 103 Arizona 194.
3 Arizona 194.
Correct, Your Honor.
Those in your briefs?
They were not, Your Honor.
Okay.
As I thought about this case for oral argument, I anticipated that question. I had not thought about it at the time the brief was prepared.
That's okay.
What's your position in regard to counsel's that the consideration, and I'm going back to this issue of what really was the option agreement, the written form of the agreement, what was that? And I believe his position was that the consideration was based solely in the payment of the $2,000. There was no consideration until such time as he paid the $2,000. What's your position in regard to that?
That does make this an illusory contract, Your Honor. What Mr. Sullivan is stating is, I'm not bound by this agreement unless I pay the option price. That's the only way I can be bound. But why would the agreement ever be enforced by the optionor unless the option price wasn't paid? It makes the agreement, as far as any binding obligation on the part of Mr. Sullivan, meaningless.
But Mr. Sullivan was fairly clear that it bound your client.
Yes. Well,
what he said, I think, was she could not reject the offer if it was made.
That was the argument that was just made. There was a different argument below at the trial.
But the tender, excuse
Tender,
me.
I'm sorry, I
Excuse
didn't
me.
mean
No, you're right. Go ahead, I'm sorry.
Mr. Sullivan's position in trial actually was that this option agreement didn't come into play at all. His position at trial was, I had my lawyer prepare these two separate agreements, the option purchase agreement and the rental agreement, and that was a package deal. When you decided to use your rental form, landlord, because that's what this party does, they rent about 80, 100 homes throughout the valley. You, in effect, rejected the other part of my package deal. There was no option to purchase agreement on the table. That was his argument. That was contradicted by the testimony. I mean, he signed the option to purchase agreement, had a change made to it at the request of Ms. Fernandez, even after that had been rejected, and then signed it. So the argument was not a valid argument, but that was Mr. Sullivan's position below.
Why did your client not require the payment of $2,000 at the time of the execution of the option agreement?
She was the party involved in the negotiations and the signing, but the money was being handled by her office. And what we have from the transcript is that there was some confusion by her bookkeepers. They apparently had some new bookkeepers come on board. She didn't realize until 2 months into this agreement that the $2,000 hadn't been paid. That was to flow outside the signing of the agreement.
What did she do at that point?
She said, okay, if you're not going to do the option to purchase, I don't want to rent the property to you. You leave. But Mr. Sullivan refused to leave. He stayed in the premises and used these premises as a vacation rental property. While he was paying $5,000 per month for rent, he was advertising the house for $7,000 per week for his vacation rental business. That's what ultimately led to the eviction. That was a violation of the terms of the lease.
And of course, the violation of the terms of the lease isn't before us because there was a justice court action, and then that barred the claim here, the complaint here for breach of the lease.
To say that the terms of these two documents are intriguing would be an understatement. My recollection is that there are only, and I agree the rental agreement isn't under consideration here, but there are 3 provisions within the rental agreement that allow for its termination. The significant aspect for purposes of my question is, do I understand, and I'm going back to the issue of whether or not the option was a binding agreement, that the underlying rental agreement could be terminated without voiding the option to purchase agreement?
That is correct. There was call it a cross-default provision in the option to purchase agreement that says you have to be current in your rent before you can exercise the option. But there was no similar provision in the lease that says if you haven't made those $2,000 monthly payments, we can terminate the lease.
So he could go the year, make his rental payments. They could terminate the rental agreement for some reason, and the option to purchase agreement would continue to apply according to the party's understanding for how long?
It had a term of 12 months as well. Your Honor.
It was based on the one provision in the rental agreement that it terminated at the end of the 1 year.
There's a specific provision in the option to purchase agreement, Your Honor, that says the term of the option is for 12 months. So,
I may have missed that.
And then it does say that there are 3 ways to terminate it.
Mm-hmm.
And default's not one of them.
Default of the lease is not.
Default under the option agreement is not even a basis for termination. The option agreement says it can be terminated for 3 reasons: the closing of the purchase of the property, the option termination date, which is the 12 months, or mutual written termination. It's not even written in there that breach of the option agreement is a basis for terminating the agreement, which causes me to question Mr. Barsky's position that she could have sold at any time, because as I read that agreement, she couldn't get out from under this option contract even when he breached the option contract. What's your view on that, if you've thought about it?
Yeah, I had not thought about it, Your Honor. And the practicalities of this were the option price, the $1.55 million, was an attractive price. That's what led to the lease. And indeed, if Mr. Sullivan had chosen to try to exercise the option within that 12 months, my client would have happily taken the money at that time. A couple things about the agreement itself that I would like to bring to the court's attention, and that's there is not, while the stated consideration is the payment of the purchase price, there is an agreement on the part of Mr. Sullivan that he is going to pay the purchase price. There is a promise that's consideration here, not just the performance of the payment itself.
Doesn't say that, though.
Well, it implies that, though, Your Honor. Under key terms, right at the very beginning, it says, owner hereby agrees to grant to optionee, and optionee hereby agrees to obtain from owner. And then it goes on to describe the option. Well, for optionee to obtain from owner, that necessarily implies that the optionee has to pay the option purchase price, or the option price.
Isn't there a better argument about consideration, the consideration being they have agreed, carved in stone, a purchase price of 1.55, and each side assumes some risk, each side assumes some unknowns in setting that. Why is that not consideration, setting in stone a purchase price that may or may not in 12 months be attractive to the buyer or the seller? Somebody's going to be on the bad end of that deal.
Well, I wouldn't go that far, Your Honor, because that's just the nature of the option. If there wasn't this reciprocal promise about paying the purchase price, then the option really just binds the optionor, here the homeowner, to sell at that price if the option is exercised.
You wouldn't argue that she incurred some potential risk or detriment by agreeing to that price? I mean, I'm trying to help you here with saying that there was consideration contemplated by the four corners of this document beyond the payment of $2,000, but you don't like that argument? Or you do if it helps you?
If it helps me, Your Honor, I'll take anything I can, but that's...
It works for me.
Can we back up to something you said a minute ago? You're talking about the key terms and the options of option property. Owner hereby agrees to grant to optionee, and optionee hereby agrees to obtain from owner. Doesn't hereby obtain from owner, hereby agrees to obtain from owner the exclusive option to acquire. So aren't we back to that issue of this is an agreement to agree to an option?
No, no, Your Honor, I don't think so. It's not an agreement to agree. The tense is the same in both clauses. Owner hereby agrees, optionee hereby agrees. It's meant to be a present promise. This is the operational language in the agreement.
But they agree to obtain. They don't hereby obtain. It's not a, this doesn't acquire the option, does it? They agree to obtain the exclusive option to acquire the real property. I'm just puzzled by the language of this. It seems like it was just as obtusely written as could possibly be. And so what we're trying to do is put it into the context, as Judge Downey said, of who's bound, who's obligated, what's the nature of the burdens they've each taken on in entering into this agreement. Can you help me with that?
Yes, Your Honor. I can take no blame or credit for the drafting of this agreement. It was not done by me, but
It was done by Mr. Sullivan's attorney, wasn't it?
it was, yes.
Yeah.
And that's clear from the record. The agreement evidences a present intent to be bound, and you see that in several places through the agreement. One of them I pointed out in the brief is Section 16 of the agreement, where it has both parties acknowledging that this is a binding contract.
But a binding contract for what?
A binding contract for a purchase option.
So you're saying that, but of course it's binding only if they pay, I mean, their argument is it's binding only if he pays the $2,000.
Which would make this illusory, would make it not a binding contract.
Although his alternative argument is she's bound. He's not. As soon as, in other words, if he tendered the $2,000, she's bound to accept it or she's in breach. But he has no obligation.
Correct, which would be a binding contract upon the option or the owner as described here, but not on the optionee.
Okay. So like an offer to an offer. I'm getting back to law school.
This,
Okay, what else do you think shows a present intent, a present promise?
Section 5 of the agreement. And this goes to the contention that somehow the payment of the option price was a condition precedent. Section 5, the second sentence there, expressly says that there are no contingencies to this. It says the option is not contingent upon optionee's ability to obtain financing from a lender or for any other reason. There were no contingencies in this agreement.
So you're saying that the payment or non-payment was not a contingent entitlement?
Correct, Your Honor.
Anything else in the four corners of the document to show a present, that it was binding on both parties?
No, Your Honor, that's what I wanted to bring to the court's attention. I do want to address the issue of damages. That is the second issue raised by the appellant here. This is a contract case, and the damages here are compensatory damages. The purpose of compensatory damages is to put the parties in the position that they would have been in if the contract had been performed. If the contract had been performed, then the homeowner, the owner, would have received 12 payments of $2,000 each, or $24,000. Those are the damages. That's the nature of this type of transaction, that Mr. Sullivan was willing to pay for the right to be able to purchase this property on specific terms over a period of time. He was to pay $2,000 a month for 12 months for that right. He didn't pay that in order to put the parties in the position that they would have been in had the contract been performed. Then the judgment for $24,000 in favor of Homes, et cetera, should be affirmed.
Counsel, did you represent Ms. Fernandez at the Justice Court?
I did not. That was specialized landlord-tenant counsel, Your Honor. But I am familiar with what happened there.
Thank you. At that proceeding, my recollection of the transcript is that he in Mr. Sullivan's examination of Ms. Fernandez, which seems to go on interminably, but he says he keeps asking her about this issue of did she receive any money? Did she receive any money? And it's the position I think counsel is asserting today, that not having made the payment, he's not bound by the agreement. And then he says, why would I have made the $2,000 payments to maintain an option on a piece of property I didn't want to buy? You with me on that?
I'm not familiar with that part of the transcript, Your Honor. I can tell you, though, from the transcript in the Superior Court, that the testimony of Ms. Fernandez was that Mr. Sullivan assured her that he did want to buy the property, that this wasn't just an option, but he fully intended to exercise the option. And her testimony in the trial court was that Mr. Sullivan told her, why would I pay you $2,000 per month if I wasn't going to buy this property?
Thank you.
If there are no other questions from the court, I'm finished with my prepared remarks.
A few things I want to touch on. One was Judge Downey's reference to whether you can get out of the contract if, even if there was a default in those three provisions. It was the appellee's testimony at the trial level that this option was revocable for non-performance or non-payment, and that's on page 6 of my opening brief, and that cites to the transcript at page 112 and 113. So I do think that revocation was and is the only remedy that they should have been permitted to pursue in that circumstance.
So you're saying the optionor had the option to revoke for non-performance?
Yes.
Or both parties had the right?
I think, yeah, my client had the right to not perform, and then upon his non-performance, she had the right to revoke. So she didn't have to refrain for a year is basically what I'm saying. Upon his non-payment, she could sell to anybody. She's entitled to the property appreciation. She's entitled to all that. And that really, I mean, going back to the contract again, I think the court's well aware of it. You know, it mentions that they agree to obtain the option, the options agree to be given, but it's on the terms and conditions set forth below. I mean, Ms. Fernandez negotiated on her own terms that you can't exercise the option if you're not current on premium payments. It also sets forth in there that payment is basically
I'm sorry,
On rental payments.
rental payments.
no, on option payments, premium payments.
No, on rental payments. I think the agreement says, maybe I misread it. I thought the agreement said that she put in a clause that said if you're not current on your rental payments, you can't
okay.
exercise. Is that?
You're right.
Okay, okay. Does that eliminate that argument?
Well, I still think, you know, I still think Ms. Fernandez would have the right to go forward with the exercise of the option if he wasn't current. So that's still our
That
position.
contradicts the terms of the option contract that says it only terminates on 3 conditions.
True, but, you know, again, with their testimony at the state court level, that this was revocable. I think that's both parties' understanding of it. So, so that being said, I mean, I think our final position here is, you know, the offer, you know, this agreement was an embodiment of an offer. Once my client tenders that premium payment, that offer becomes irrevocable. And upon that irrevocability, that's when my client actually gets something in this circumstance. Without him receiving anything, you know, the irrevocability of the option, the certainty that he can possibly get that future price appreciation, there's really no damages that lie here in this circumstance. So I think that's really our bottom line. And the last thing I have, and I'll entertain any questions after that, it is the trial transcript referencing the detrimental reliance is, I think, a page. It's on page 110 of the trial transcript where the court inquires into the detrimental reliance. So I'll let the court inquire into whether sufficient argument was raised or inquiry was made at the trial court to preserve that on appeal. So that being said, I have nothing more unless the court has any more questions.
Thank you, counsel.
Thank you.
Oral argument is complete at this time. We are taking the matter under advisement at this time, and our ruling will issue in order. Thank you, counsel.